Hello, this is Sally Annero from Tailor Wessing, and welcome to our webinar. This is part of our ongoing webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees are going to be very familiar with our previous topics. We've included issues such as managing cybersecurity risks. We've touched on data transfers and the privacy shield. We've looked at the use of CCTV and data protection employment. And of course, we've been looking at the EU data protection regulation, among other subjects. Recordings of those previous webinars and others from Tailor Wessing are still available from our website or our global data hub microsite in case of our data protection webinars. And you can access those if you've missed them and you'd still like to engage with any of those topics. Today, we will be focusing on some of the key compliance requirements under the new European data protection law, the General Data Protection Regulation, or GDPR, that comes into effect on the 25th of May 2018. This is part of a series of our webinars where we're providing sort of some insights and into different aspects of the GDPR, alongside those other topics that we're also covering through our wider, more general webinar program. For those of you who are unfamiliar with this webinar technology, just to let you know that there's a Q&A button at the bottom of your screen, so please submit questions at any time. I can't promise that we will get to all of them this afternoon, but of course, any we don't get to, we are happy to follow up with you on outside of the webinar. There's also a survey button, and you can leave any feedback both during and at the end of the webinar. So, for those of you who are new to Tailor Wessing or new to our webinar program, hello and welcome. As you'll see from this slide, Tailor Wessing is an international law firm. We act for a range of leading clients in local and international markets where we provide a full-service law firm offering from our office footprint that spans across Northern, Central and Eastern Europe, the Middle East and Asia. And we've listed some more details about the firm on the slide deck for you. Today's webinar is brought to you by Tailor Wessing's Data Protection Practice. We advise on the full range of both data protection and information law issues from our office footprint. Our international data protection practice is a global 22 partner-driven team, and we're also complemented by an international network of data privacy law specialists. At Tailor Wessing, we have a dedicated microsite specifically for all things data protection, our global data hub. And from this page, you'll see that you'll be able to access news, weekly updates. We also have a bi-monthly mail shot if you register. We also focus on some topical issues where we look at developments that are raising data protection or privacy issues or challenges. And you can access information about forthcoming webinars along with recordings of our archived webinars. As mentioned, my name is Sally Annero, and I'm a senior member of the London Data Protection Practice. But today I'm giving the floor over to my colleagues, Jean-David Bello from our London office and Paul Voigt from our Hamburg office. We also have my colleagues Lucy Lyons and Debbie Haywood. And their profile details are available on these slides for your information. As mentioned, today's webinar is part of a series of webinars where we're focusing on key compliance aspects of the GDPR. A key differentiator under the GDPR is that it's not enough to be compliant. It's also necessary to evidence that compliance. And Jean-David is going to be looking at the role of accountability under the GDPR and how to take that extra step towards demonstrating compliance. Following Jean-David, Paul Voigt will be looking at the role provided by the GDPR for data protection officers, or DPOs. He'll be considering when a company may need a DPO and also touching on some considerations relevant to appointing a DPO, both generally and against the context of the current German requirements for DPOs. Following Paul, Lucy Lyons will look at the role of data protection impact assessments. She'll be considering the circumstances when an impact assessment is needed and the approach. And then finally, Debbie Hayward will be looking at data security and the breach reporting obligations that arise, not just under the GDPR, but also the similar obligations that can be found in the recently finalised Network Information Security Directive. Then following this, we're going to have a few polling questions where you have an opportunity to learn in the aggregate the views of the wider attendees, their thoughts on the state of progress of their actions towards the GDPR, and I'll also have some details about the date and the subject of our next webinar. And so with that, let's move straight on to the main topic of today, the GDPR, and I will introduce and pass over to my colleague John David to talk to us about accountability.
Thank you very much, Sally. During the next 10-15 minutes, I'm going to focus on the new concept of the so-called accountability principle, which really is the cornerstone of the GDPR. I will explain what it means, how it will impact businesses on their approach to data privacy compliance, and what they can do to go through that compliance burden required by the accountability principle in order to demonstrate compliance with the GDPR. So, although the GDPR entered into force in May of this year, businesses will have to comply with it by May 2018, which means that they roughly have 2 years to prepare for it and hit the GDPR rules. So where you are now in 2016 and where you should be in May 2018, there's a long journey for you to go through. And if you have not yet started your GDPR compliance journey, you're not alone, but we will see why you should start sooner rather than later, as the compliance journey is a long one. But before we look at the accountability principles, the first thing that you need to determine is whether the GDPR will apply to your business or not. To do so, you need to look at whether you have an EU establishment. By EU establishment, we mean that if you have a branch or a subsidiary in the European Union, then it's very likely that you will be caught by the GDPR. But if you are a non-EU business, let's say if you are based in the USA, for instance, you might be caught as well, even if you have no office in the European Union. So, two factors are important. The first one, if you are a non-EU business, but you are offering goods or services to the data subject in the European Union, you might be caught. And the way to assess it is that it must be apparent that as business you have the intention to offer services to the data subject in one or more member states. So some factors could be that the use of a language or a currency generally used in one or more member states with the possibility of ordering goods and services in that language, or if you mention customers or users who are in the Union, we make apparent that the controller will envisage to offer goods or services to the data subject and therefore be called by the GDPR. The second factor is monitoring data subject behavior, provided that it takes place in the European Union. Again, how do you assess it? Well, a few examples here. If you are tracking individuals on the internet, if you are using profiling techniques in order to take decisions concerning those individuals, or if you are analyzing or predicting their preferences or behavior, again, even if you are a non-European business, you are likely to be caught by the GDPR. Now, what does this accountability principle mean? Well, as I said earlier, it's a new concept under the GDPR, and data controllers will have to comply with this principle. Two terms are important. The first one is being able to demonstrate compliance, And the second one is being responsible for that compliance, which means compliance with the processing principles of the GDPR, which may be quite narrow, but actually the impact it has on your processing activities is important, because demonstrated compliance will involve implementing more processes and maintaining a proactive approach to your compliance program as well. And failure to do so may expose your business to high fines, which can be up to 4% of a business annual turnover, or 20 million euros. So, no matter the size of a business, its industry sector, businesses will have to put in place new processes, new practices that will probably change the way they currently approach data privacy compliance. That's what demonstrating compliance means, and we recommend that you create an audit trail. The first step that we recommend that you follow is an assessment of your current data privacy practices. That means either carrying out an audit, or at least a gap analysis of your current compliance with the European Data Protection Directive against the GDPR requirement. One example could be to look at your consent mechanism that you have in place, such as how do you collect consent, how do you use consent for your marketing activities, for instance, because the consent test is much higher under the GDPR than under the directive. Bear in mind also that you will have to take into account the e-privacy directive in relation to marketing activities as well. Doing a gap analysis also means that you may have to assess your processes and or technologies, but the most important thing will be for you to identify the key compliance issues that you will need to focus on. The second step that you recommend that you take will be to implement a data privacy governance structure. Some of you may already have a privacy structure in place, but if you don't have one, you will need to create one, or at least think about it. One very important thing to do will be to involve senior management at the outset of the creation of the program, just because they will be able to support you during the program, and of course there will be the people who will provide the budget as well. A very important thing to do will be to assign roles, tasks, responsibilities, and clear reporting lines accordingly. Again, as I said earlier, you will need to allocate a budget for it, and include a GDPR compliance project into your wider data privacy compliance programs, and set out milestones as well that you will have to meet. If you have a data protection officer or DPO, you will need to involve your DPO as well. And an important thing to do will be to arrange meetings and monitor compliance as well, and report to the DPOs and or the management board, so that everyone is aware of what you are doing. The third step that we recommend that you take is the creation of information notice. It flows from the transparency requirements under the GDPR, and the main requirement will be for you to create a personal data inventory, which will mean that you will have to have a list of all your data processing activities. What could be useful will be for businesses to go through a data mapping exercise, differentiating between your activities as a data controller and your activities as a data processor, and that will need to include data transfer as well. So that means that you will have to sit down with your business and IT people to make sure that you understand your data processing activities, because you will have the obligation to evidence it under the GDPR. One practical way to do so will be to look at your data protection notifications or authorization, because in some countries, some processing activities need to be authorized, such as in France, for instance. If you want to transfer personal data from France to a country outside the EEA, you will need to get an authorization from the French Data Protection Authority. Again, very important will be to keep that inventory up to date and accurate. So you will need to make sure that someone monitors the inventory as well. The next steps, again, in relation to transparency under the GDPR, is that both data controllers and processors will have the obligation to inform data subjects about their processing activities. And this will mean that you will need to be more transparent about it, and you will need to be able to evidence it. One way of doing it will be to review your data privacy policies, for example, so that you ensure that the GDPR requirements are complied with. Another step that we recommend that you take is the implementation of technical measures, which applies to both the data controllers and data processors, but bear in mind that data processors have the obligation to assist data controllers in implementing such measures. One new obligation under the GDPR will be for businesses to consider new privacy techniques, such as pseudonymization, or privacy by design and privacy by default techniques. So again, if you are going to implement a new project involving personal data, it might be a good idea to sit down with the business people and other people involved in the transaction to make sure that you can embed such techniques into your projects. Another important security technique will be to assess whether you need to put in place data privacy impact assessments. I'm not going through this into detail because my colleague Lucy will talk about it later on. But again, you might want to sit down with your cybersecurity teams to make sure that you know when to implement data privacy impact assessment. Finally, personal data breaches is a very important topic under the GDPR because there is an obligation to report personal data breaches. There is a definition of personal data breach under the GDPR, so make sure that you know what it is. And the reporting of such breaches forms part of the accountability principle because the controller will have to be able to demonstrate in accordance with that principle that the personal data breach is unlikely to result in a high risk to the rights and freedom of natural persons. It is very important as well that you comply with the time frames of the GDPR. To do so, we recommend that you have in place a written personal data breach procedure so that you know what to do in case you identify a personal data breach. What this means is that you will have to create one, but you will have to test it as well to make sure that it works properly. The reason why you need to be so organized is, well, first of all, you need to comply with the requirements, but as I mentioned earlier, the fines can be very high, and for personal data breaches, it may attract a fine up to 2% of the annual turnover of a company. So again, what we recommend in terms of personal data breaches is that you identify who is responsible for dealing with the breach. You identify and assign responsibility to a core group of individuals, which could be legal, IT, PR, your management team, and external counsel as well. The important thing for you, the reason why it is important for you to do it is because you will have to communicate internally and externally potentially as well to authorities and data subjects. So just to conclude on this accountability principle, There are enhanced obligations on controllers and processors, enhanced rights for data subjects. Fines are likely to be higher, and you will have to reduce the risk of not breaching the GDPR. And therefore, you will need to think about a proactive approach to privacy compliance to manage the risks effectively. And you will need to show that you are on top of things and that you understand the compliance obligations, the risk, and you know how to deal with them. That's what demonstrating compliance means. And it's not about just showing that the business can achieve compliance, but it actually has to reflect and record actual compliance. And one way of doing it will be via the data protection officers, which is what my colleague Paul Vogt, who is a partner in the IT team in Germany and an expert in data protection, will talk about now.
Thanks very much, Jean-David. Thanks very much. So I will speak about the requirement to implement a data protection officer under the GDPR. The obligation to appoint a data protection officer in certain cases is likely one of the politically most contentious innovations of the GDPR, and this is due to the fact that most jurisdictions do not know the concept of a mandatory data protection officer. We, in Germany, we actually have introduced this concept for a couple of decades now, and we had quite good experience with it so far, so nothing to be afraid of. What is the reason to implement a DPO? So the aim, and I'm sorry, there is a slide missing. The aim is actually to have one central person advising the company on compliance with data protection law and acting as a contact person both for supervisory authorities and data subjects. So one person who manages data protection internally and where the strings come together. The appointment of a data protection officer is unlike in Germany, where actually every mid-sized company is obliged to implement a data protection officer. It's very limited under the GDPR. So according to the GDPR requirements, the appointment of a data protection officer is only required either when the company's core activities consist of either data processing operations which require regular and systematic monitoring of data subjects on a large scale, or if the processing on a large scale of sensitive data is involved. Yeah, so very limited cases. You see the terms that are used by the GDPR are quite vague. What is a core activity of a business? What is systematic monitoring, and what does large scale mean? No one really knows actually, so we will have some uncertainty in the beginning. When does a data protection officer actually have to be implemented? What we likely can say now is that companies very regularly dealing with customer data, such as credit agencies or data traders, are much more likely to fall under the respective obligations than, for example, companies that just do HR data processing, for example, for limited HR purposes. So who actually qualifies to be a data protection officer? A DPO does not necessarily have to be a lawyer, but he should have certain expert knowledge with respect to data protection laws and practices, and should have a good understanding on what kind of processing activities are within the law and what kind of processing activities are overdone, so to say. In addition, the DPO should have a reasonable understanding of the company's internal organizational structure. Yeah, so he should know who is responsible for what kind of activities. He should have an understanding what departments actually exist and what departments process what kind of data, who is responsible, who he has to approach in case he has questions. But he also has to have a good understanding of the IT systems that the company uses in order to be able to assess whether these IT systems are in compliance with European data protection law. The DPO may either be employed and be a so-called internal DPO, or he may be an external service provider, an external consultant offering his DPO services. Whether it makes sense to have an internal DPO, so an employee, or rather an external DPO, will depend on the kind of services you need from the DPO and on the kind of your business. So, for example, if you're a multinational corporation with businesses in many countries, it is likely helpful to have an internal DPO in place, because otherwise it will almost be impossible to bring all the strings together to collect the required information in order to actually be able to advise on data processing activities. If you don't have the information, basically the answer you will give will always be wrong. So this is very important. And also it will help if the DPO is very well connected internally, so he can actually give advice to the right people. If you, however, like a very small national company, an external data protection officer may also do. But we believe that the importance that the internal DPO will be the rule under the GDPR, and that the internal DPO will be much more important under the GDPR than the external DPO. The DPO must, of course, be granted a certain level of independence, so he shall be free in his advice and shall not fear repercussions from his employer. And this leads to a certain protection against any kinds of sanctions on grounds related to his tasks as a DPO. But having said this, this protection is quite limited under German law. For example, now it is basically impossible to terminate the employment relationship of an internal DPO, even if his work is bad, because his protection is just so high. The protection under the GDPR will not be as high. So basically, what are the pros, what are the cons of implementing a DPO? A pro is certainly that you can reduce bureaucracy by having just one person responsible for data protection and having one person communicating with the respective departments and having a good understanding both of data protection law and of the internal data processing activities in place. And if you compare bureaucracy under the GDPR with current bureaucracy, you will see that in many European countries you have filing obligations before local regulators, and those filing regulations will fall away and will be replaced by an internal compliance system including the DPO. You also, if you have a DPO in place, this will lead to effective compliance management, and certainly it can lead to risk reduction, because if you have a look at significant data protection or data processing activities before you implement them, you still have the possibility to adapt them without major efforts, and this will potentially protect you from fines at a later stage, and this is much more important under the GDPR than it is now, because the fines are just so much higher than under current national data protection laws. Of course, not everything is positive with the DPO. As we mentioned before, it is difficult to assess whether you're actually obliged to implement a DPO or whether you're not. So there is some kind of risk that you are obliged to implement one and you haven't done it, and this will actually subject you to fines of up to 10 million euros or even up to 2% of the company group's worldwide turnover, whatever is higher. So actually quite a high risk. So what should you do now? Basically, it will be helpful to assess now whether your company falls under the GDPR requirements for the mandatory implementation of a DPO or not. And if you fall under it, it may make sense to already commence implementing structures to have a DPO in place and to provide him with the resources he needs and to introduce him already and to create internal awareness that a data protection officer needs to be installed. If, according to the wording of the GDPR, you believe you're not required to implement a DPO, unfortunately, you're still not safe because every country, every member state has the discretion to enact own national laws leading to much higher requirements with respect to the implementation of DPOs. Germany, for example, has just very recently published a draft for a new Data Protection Act, and the implementation of DPOs will be required in many, many more cases than actually mentioned under the GDPR. So we are far from harmonization, unfortunately. And we will continue with Lucy Lyons and data protection impact assessments.
Thank you, Paul. As my colleagues have already mentioned today, and many of you will already be getting to grips with, at the heart of the GDPR is the formalization of compliance processes, requiring that this is evidence. And the DPIA, the Data Protection Impact Assessment, are one example of this. The concept of a DPIA may already be familiar to you. The ICO published its Code of Practice for conducting DPIAs back in 2014, and across Europe, similar assessments have been prevalent for some time. Under the GDPR, these concepts are further developed, and specific analysis against the GDPR requirements will be needed, specifically where processing operations are likely to result in the high risk to the rights and freedoms of data subjects. So what is a DPIA? The data controller is responsible for carrying out a DPIA to analyze the origin, nature, and severity of the risk to data subject rights and freedoms. In doing so, the context and purposes of the intended processing will need to be analyzed. There are two strings to the DPIA analysis. Firstly, to identify if there is a risk present and assess the level of that risk, and two, determine measures which could be used to show processing is in line with GDPR to protect the personal data process. What's clear is that it's vital that the DPIA is carried out before the relevant processing starts. If the intended processing risk cannot be mitigated by taking appropriate steps with regard to available technology and cost of implementation, the applicable supervisory authority should be consulted. As always, and as my colleagues have mentioned, the sooner any risks are ruled out or identified, the better. A well-prepared business will be able to put in place appropriate remedies or take other required courses of action without delay. You can see on the slide there the minimum requirements set out in the GDPR for the elements of DPIAs, and these uphold the key principle of privacy by design, which is formalized throughout the GDPR. So the next question asks, when should they be carried out? The GDPR directs that these should be carried out where a type of processing, in particular one that uses new technologies and taking into account the nature, scope, context and purposes of the processing, is likely to result in high risk to the rights and freedoms of natural persons. As with other requirements under the GDPR, there's no definition as of yet of the high risk, and it's yet to be outlined by supervisory authorities, but it's likely to result when the extent and frequency of processing adversely affects or otherwise interferes with the rights and freedoms of the data subject, particularly where innovative or disruptive processing activities are used. For this reason, it may be worth considering a two-stage process for DPIAs to tackle the issue of unknown unknowns. Firstly, A high-level DPA could be carried out to pose the initial questions about the intended processing operations. If after this initial assessment, any potential risk areas are identified, a second DPIA can analyse processing operations against the full depth of requirements under the GDPR. The GDPR highlights particular factors to consider when carrying out DPIAs, such as the extent to which large-scale processing operations are carried out, if there's significant volumes of personal data contained in the processing operations, the sensitive nature of the personal data, or where new technology has been developed and deployed on a large scale, and significantly, where processing operations make it harder for data subjects to exercise their rights. And you can see on the slide there further indications of when a DPIA will be required under the GDPR. The GDPR allows for a supervisory authority to create a publicly available list of types of processing operations which will require a DPIA and those that won't. These lists will also be shared with the European Data Protection Board, which will subsequently issue an opinion following the adoption of such lists by supervisory authorities. If a particular supervisory authority has not established a list, the competent supervisory authority will apply the consistency mechanism in considering these approved processing operations. As with much of the GDPR, the degree to which supervisory authorities take complementary positions will be significant. Where lists for DPIA processing operations are uniform or near uniform across supervisory authorities, this could increase the ability of businesses to quickly identify processing risks, helping to ensure efficient compliance. A GDPR also acknowledges that it may be reasonable and economical for the scope of a DPIA to extend beyond one project, so that the assessment is carried out across an industry sector or where public bodies intend to establish common processing operations. Again, the extent to which it is practically supported by supervisory authorities will be important. Just to briefly look at the scope of the DPIAs and what we can look at to provide guidance, the GDPR does set out an approved code of conduct which take into account various processing sectors and the specific needs of small to medium businesses. And if applicable, data controllers should consider these when carrying out a DPIA. It may also be appropriate to seek the view of data subjects or their representatives depending on the intended processing operations under a GDPR requirement, which could be a particularly onerous obligation under the GDPR, and it will be really useful to gain some supervisory authority guidance around this point in particular. As we've touched on before in the accountability section of this webinar, a central theme of the GDPR is that compliance reviews are ongoing, and assessments of DPIAs are no exception, particularly where processing operations change and where these could impact data subject rights and freedoms. These need to be reviewed on an ongoing basis, and as Paul mentioned, where a DPO is used, they'll be central to reviewing these ongoing compliance obligations, particularly within respect to the DPIA. So, what do you do if you do identify a high-risk processing operation? Where the high risk of processing operations is identified, and the data controller believes that reasonably available technologies and their implementation costs do not mitigate this risk, the supervisory authority must be consulted. The extent to which companies and supervisory authorities will agree on the reasonably available technologies and costs could prove very influential. The process for this review will be where the supervisory authority is of the opinion that the controller has insufficiently identified or mitigated risks. Within 8 weeks from the request for consultation from the data controller, the supervisory authority will provide written advice to the data controller and processor, if applicable, and may use any of its investigatory or corrective powers. It's important to remember the wide nature of the powers in Article 58 for the supervisory authorities, which include investigative powers, such as obtaining access to premises, and corrective powers, such as imposing a temporary or definitive limitation or ban on processing. This period, the 8-week period, may be extended by 6 weeks depending on the complexity of the planned processing, and all time periods may be suspended if the supervisory authority which has requested information that's not been received. And on the slide there is a list of the type of information that the supervisory authority may require. So we still await further, more detailed supervisory authority guidance. But it's clear that those businesses that move now to get their ducks in a row and begin to build DPIAs into current and future processing operations will be ahead of the curve in tackling this compliance requirement. I'll now hand over to my colleague Debbie Hayward to talk about security and breach reporting under the GDPR and NIST.
Thanks, Lucy. Security and breach reporting, I mean, it's a big issue. A government survey published in May of this year revealed that 2/3 of large UK businesses were hit by cyber breach or attack in the previous 12 months. And nearly 70% of attacks on businesses involved viruses, spyware or malware, most of which, claimed the report, could have been prevented by following the steps recommended in the government's Cyber Essentials schemes. Of course, not all security breaches are the result of hacks. Many are due to human error, for example, sending information to the wrong recipient, losing documentation, or failing to redact personal data. Whatever the cause of a data breach, it can cost a business millions. Businesses need to focus on data security, not simply because of the costs and the reputational damage breaches cause, but also because of incoming legislation which steps up security and breach reporting requirements and provides hefty sanctions for non-compliance. I'll be adding to the recommendations that Jean-David made in a minute, but first we need to take a look at what the new legislation requires. And I'll be looking not just at the GDPR, but also at the new Cybersecurity Directive, which is less wide-ranging in the businesses it applies to, but contains similar, although not identical, breach reporting requirements. Before I get going on the detail in the law, I do just want to touch on the relevance of incoming EU legislation in the UK in the wake of the EU referendum results. The Data Protection Regulation and the Network Information Security Directive, which is also known as NIST or the Cybersecurity Directive, are both obviously EU pieces of legislation. As you know, the GDPR will be in effect automatically in EU member states from the 25th of May 2018, whereas NIST requires member states to introduce implementing legislation by the 9th of May 2018. This of course begs the question as to how far the UK need take notice following the results of the EU referendum. Well, we'll almost certainly still be an EU member state at the end of May 2018, and the ICO has already said that UK organisations should work on the assumption that the UK will either implement the GDPR or very similar legislation in order to ensure that the UK maintains adequacy for EU purposes and can continue to receive EU personal data. But less has been said about NIST, which affects only some businesses, and it remains to be seen whether and to what extent it takes effect in the UK. A new UK National Cyber Security Centre is set to open shortly, and given the cross-border nature of many cyber attacks, it seems likely that the UK will certainly seek to cooperate with the EU in this field. So having tried to explain that we think both pieces of legislation are very relevant to us, I'm going to start by outlining the requirements under the GDPR in terms of security and breach reporting requirements, which are covered in Articles 32 to 34. In terms of security measures, under Article 32, controllers and processors are required to implement appropriate technical and organisational measures to ensure a level of security appropriate to the risk. And the assessment of what might be appropriate involves considering the context and purposes of the processing, as well as the risk of varying likelihood and severity for the rights and freedoms of individuals. Appropriate measures which can be taken are set out as possibly including pseudonymization and encryption, ensuring confidentiality, integrity, availability and resilience of processing systems and services, the ability to restore availability and access to personal data in a timely manner in the event of an incident, and regular testing and evaluation of the technical and organisational measures designed to ensure the security of data processing. Controllers and processors are also required to ensure that anyone acting under their authority accessing the personal data does so only in accordance with their instructions. Compliance may, but does not have to be, demonstrated by adherence to an approved code of conduct or certification mechanism. Turning to breach reporting, there are provisions around reporting both to the supervisory authority, or SA, in Article 33, and on reporting breaches to data subjects in Article 34. Data controllers are required to report a personal data breach to the competent SA without undue delay and, where feasible, not later than 72 hours after becoming aware of it, unless the personal data breach is unlikely to result in a risk to the rights and freedoms of data subjects. If a notification is made after the 72 period has expired, the data controller must explain the reasons for the delay. The notification given to the SA has to include at least a description of the nature of the breach, including, where possible, the categories and approximate numbers of data subjects and personal data records concerned, the name and contact details of the relevant data protection officer or contact point, the likely consequences of the breach, and the measures taken or proposed by the controller to address the breach and or mitigate its effects. Where a personal data breach is likely to result in a high risk to the rights and freedoms of a data subject, the controller also has to communicate the breach to the data subject without undue delay. The communication must describe in clear and plain language the nature of the breach and at least give the name and contact details of the relevant DPO or contact point, the likely consequences of the breach, and the measures taken or proposed by the controller to address the breach or mitigate its effects. There is, however, no requirement to make a notification to the data subject where any of the following conditions have been met. Technical and organisational measures have been applied to the personal data which will render it unintelligible to unauthorised persons, so for example encryption. The controller has taken steps to ensure the originally high risk is no longer likely to materialise, or that to notify each data subject would involve disproportionate effort, in which case a public communication or other method of information is used which would inform the affected data subject in a similarly effective manner. Where a breach is reported to an SA and not to the data subject, the SA may require the data controller to notify affected data subjects. Data processors are also subject to reporting obligations. They are required to notify their controllers of any personal data breach without undue delay. So what exactly does this mean for controllers and processors? Controllers will have been relieved to see that the data breach reporting requirements have become more realistic than those proposed under the first draft of the GDPR as a result of intensive lobbying. The original draft required that all data breaches, no matter how insignificant, be reported without undue delay and within 24 hours. Notification of data subjects was then also required unless the relevant DPA was satisfied that data subjects had been sufficiently protected by measures such as encryption. Processors have also seen reporting requirements change from immediate to without undue delay. This emphasis placed on the controller's assessment of the situation is certainly to be welcomed, but as with all legislative requirements which include flexibility, there will also be an element of doubt as to when the data breach poses a risk and when such risk is sufficiently serious to require notification of data subjects. Different SAs may also, as they do now, take different approaches. The best way for organisations to deal with this is, of course, to minimise breaches, but also to have policies in place to enable staff to assess risk and to be able to demonstrate compliance. As with so much of the GDPR, being able to demonstrate that the proper precautions and steps were taken will be key, and I'll come on to some more suggestions as to how to achieve this in a minute. To help focus the mind, though, it's worth noting, as Jean-David mentioned, that failure to comply with breach reporting requirements under the GDPR will not just result in regulator scrutiny, negative PR, and possibly in loss of business, but there are also very real financial penalties which the regulators have in their armouries for serious failures, up to 2% of annual global turnover or 10 million euros, whichever is higher. Now, I'm just going to look at the requirements under NIST, or the Cybersecurity Directive. Now, this is going to be relevant to you if you are an essential service provider. Now, a definitive list of those who will be caught under this will be published by individual countries, but we're talking mainly about utilities and services which are considered of vital importance to the public. NIST also applies if you are a digital service provider, and that's defined as being an online marketplace, an online search engine, or a cloud services provider, so that may catch a number of you. Where sectors are subject to sector-specific union legal acts relating to information and network security, these will take precedence. So, for example, NIST doesn't apply to telecoms providers as their security is dealt with by the Framework Directive. NIST is designed to work alongside data protection legislation, but it does have different criteria. For example, it covers natural persons, which includes companies, whereas data protection law covers only personal data. Regulators have to cooperate with each other to sort out any differences and help people organise their priorities. As with the GDPR, NIST is intended to have some extra EU application and will apply to DSPs which are established outside the EU but which offer services within the EU on more than an incidental and passive basis. Organisations will be regulated in the member state of their main establishment, which will be where their head office is located. Now, note that this is a different definition from the one used in the GDPR, which states that the place of main establishment is presumed to be the data controller's place of central administration, unless the main decision-making with regard to the personal data is taken in another member state. Where an organisation is subject to NIST but doesn't have a main establishment in the EU, it has to appoint a representative in one of the member states in which it offers services, and it will be subject to regulation in that member state. There are some exceptions for micro-enterprises and small enterprises. So turning to the security and notification requirements for operators of essential services, member states have to ensure that the operators take appropriate and proportionate technical and organisational measures to manage risks. And these are defined as any reasonably identifiable circumstances or events having a potential adverse effect on the security of networks and information systems. So they have to take these measures in order to, in relation to risks posed to the security of networks and information services which they use to deliver their services, and to minimise the impact of any network security incidents with a view to ensuring continuity of service. Operators of essential services must notify the competent authority or the relevant computer security incident response team, and I'm just going to refer to these collectively as competent authorities for the sake of brevity. They have to be notified of any incidents having a significant impact on the continuity of the service they supply. Notifications must be made without undue delay and must contain enough information to allow the competent authority to determine any cross-border impact of the incident. To assess the nature of the incident, the number of affected users, the duration of the incident, and the geographical spread of its impact must be taken into account. The public may be informed of an incident by the competent authority. Now, the requirements for DSPs are slightly different. DSPs have to identify and take appropriate and proportional technical and organisational measures to manage the risks posed to the security of networks and information systems they use in the context of offering services referred to in Annex 3 within the Union. I'm being a bit detailed here because what's significant here is that it's a bit unclear about what the impact of Annex 3 is, because it just essentially repeats lists of what constitute DSP, so it's a little bit difficult to work out what you're required to do. The measures have to ensure a level of security of those systems appropriate to the risk presented, taking into account security of systems and facilities, incident handling, business continuity management, monitoring, auditing and testing, and compliance with international standards. DSPs have to take measures to prevent and minimise the impact of incidents affecting security of their network and information systems. They have to notify incidents having a substantial impact on the provision of a service, as referred to in Annex 3 within the Union, to the competent authority. Notifications have to contain enough information to allow the notified body to determine the significance of any cross-border impact. In determining the impact of an incident, the number of affected users, particularly those relying on the service to provide their own services, the duration of the incident, its geographical spread, the extent of the disruption to the service, and the extent of the impact on economic and societal activities must be taken into account. Where an operator of an essential service relies on the service being provided by the DSP, the essential service operator must also be informed. And DSPs may also be required to inform the public, or the competent authority may choose to do so. The recital states that security levels required for DSPs will vary on a case-by-case basis, and they will be subject to light touch and reactive system of supervision without being subject to general compliance monitoring. Competent authorities should only take action where provided with evidence of non-compliance. In terms of enforcement, regulators are given various general powers, but member states are left to legislate on penalties for non-compliance. So what does this mean for people who are caught and have to notify breaches? The eagle eye will have noticed that the GDPR and NIST use different criteria to set out what might be considered to be appropriate technical and organisational measures, but the intent is broadly the same. An assessment of risk has to be made, and appropriate steps need to be taken to prevent that risk from materialising and from minimising the damage if it does. Most organisations caught by security and breach requirements under NIST will also be subject to the GDPR. Reporting a breach to the SA under the GDPR will not mean there is no requirement to notify under NIST, but it is possible that notification system procedures may be rationalised by SAs in future if they're also appointed as competent authorities under NIST. So it sounds as though there is a lot to think about, but as always with this sort of thing, putting the appropriate procedures in place will make the processes much more straightforward. And here are some suggestions. Firstly, identify your role. Are you a data controller or a processor? Are you an operator in an essential service or a digital service provider? Conduct a risk assessment where appropriate and then make sure you act on the results. Ensure it's clear who is responsible for dealing with cybersecurity and data security. Ensure you have up-to-date security systems such as firewalls, encryptions and authentication and test them on a regular basis. Don't just assume that they're working. Develop a cybersecurity policy. Check regularly that it is complied with. Ensure employees receive training on the cybersecurity policy and understand when they have to report incidents internally. And restrict access to personal data to those in the business who need to have access to it. Develop a detailed breach response plan, including when to notify regulators and individuals, as well as how to handle breaches from a PR perspective. Consider making financial provision to handle any data breaches, and also think about whether you want to take out insurance to cover them, or to cover the cost of data breaches. Importantly, you need to keep records of any data breaches, what kind of data was compromised and how the breach was dealt with, as well as what steps were taken to ensure that the breach doesn't reoccur. Finally, make use of the information that's out there, for example, the government's Cyber Essentials scheme and other regulator guidance on cybersecurity and data breaches. You'll have noticed that a common thread running through all the advice we've given today, whether it's on data protection impact assessments or the audit trail or DPOs, is that it's not enough to put processes in place. You really have to check they are working on a regular basis and that they are up to date and functioning properly. And that's one of the biggest messages that we want to give you today, is you can't just sort of get everything in place at the beginning and then consider that you've ticked the boxes. This is an ongoing process. And it's really something that you have to stay on top of. And things like having a data protection officer or making sure you carry out data protection impact assessments, keeping records, having up-to-date systems, that's all going to help you comply with the new requirements. I think Sally's got some polling questions for you.
Yes, thanks, Debbie. So as is usual with our webinars, we now offer the audience an opportunity to share with each other their experience in the aggregate on some of the topics we've been talking about. First of our questions is, have you already started to audit your data processing activities against a GDPR baseline? So A is yes, B is you're scheduling to do so in the next 6 months, or C, no, you haven't yet begun that process. The next of our polling questions coming through is, have you discussed with senior management your requirement for a data protection officer? And the options for that is yes, you have discussed with senior management, or you're waiting for further Data Protection Act guidance before approaching management, or that you don't plan to do so. I think you don't quite have those questions up to provide them. Oh, you do, that's fine, okay. So I can't currently see those questions, but I gather they are in front of you, so that's great. And then the third of our polling questions is, do you currently use privacy impact assessments? So yes, or no, or sometimes on a sort of informal ad hoc basis. So whilst my colleagues are crunching those results to come up with some statistics, we're just going to have a quick look at some of the questions that have come into us. And there have been a lot of questions. And the first of the questions, which I'm going to put through to my colleague Paul, is in relation to fines. So the question is that in relation to fines for global turnover, if a company is a subsidiary of a UK company, will it be the turnover of the whole group, including the US, or just the UK group? I appreciate that, Paul, you're a German data protection expert, but I think you can probably answer for us all on the general point that is being queried around whether a fine is for global turnover or local national company turnover.
Yep. Yeah, very good question actually, in particular because it is not that clearly set out in the GDPR, but due to the recitals, we know that indeed the whole group of undertakings is concerned when we assess the fines. Whether this will actually really happen in practice and whether they will really start investigating the group turnover, or whether some prefer to rather focus on the European group or the overall group, this will have to be seen in practice. But generally, the fines can be assessed on the global company group basis.
Thanks, Paul. Actually, we also have had a question around data protection officers, but it's UK specific, so if it's okay with you, I'll step in on this one, which is
sure.
Whether the UK Information Commissioner is intending to issue any guidance on when a company in the UK needs to appoint a data protection officer, given the vagueness of the criteria. My understanding is that it's guidance in relation to from the ICO is not on their sort of immediate guidance action plan, but that there is European level guidance that is expected to be completed by the end of 2016 on data protection officers and their responsibilities. So look out for that. Then in terms of, we've also had some other questions. So we've also had we had a couple of questions that have come in around the relationship between the GDPR and Privacy Shield. In particular, we've had a question that if a company is qualified or certified to the Privacy Shield, shall it still need to comply with French regulations? I think this is in relation to a comment that Jean-David mentioned on transfers and French law. So, Jean-David, will the Privacy Shield be sufficient?
Well, the first thing to bear in mind is that the Privacy Shield and the GDPR are two different things. The Privacy Shield is a mechanism allowing the transfer of personal data from a European country to the United States only, so it's only related to transfers of personal data to the United States. And the way it works is that a US company only can self-certify under the Privacy Shield with the US Department of Commerce. So to answer the question, Sally, the short answer is yes. An organization who is based in France will have to comply with French law because under French law there is an obligation to get an authorization from the CNIL, the French Data Protection Authority, to authorize the transfer of personal data. And actually, the CNIL recently published a statement saying that it has updated its form so that if you are going to transfer your personal data to a US self-certified Privacy Shield organization, you will have the opportunity to tick a box, a Privacy Shield box, for you to be able to do so. However, what the CNIL has said is that you will have to check yourself whether the US organization that you are going to use in the US is Privacy Shield compliant. And to do so, you need to look at the FTC's website to know whether that certification is current or not. But I'm not going to detail too much on Privacy Shield because we are going to have a webinar on the 18th of October specifically on Privacy Shield. So please, I welcome you to register for it.
Thanks, Jean-David. Just one final question, because we have had quite a lot of questions in, and Lucy, perhaps you can help us with that one, which is, do you have any views on the validity of the consent collected in pre-GDPR world in the post-GDPR world? For example, if a firm's current consent does meet the Data Protection Act 1998, but does not meet GDPR, can the firm rely on the old consent? And I don't know whether this is a question you can answer with a short number of words, but given the time, that would be great.
Thanks, Sally. In short, no, the old consent won't work, given that the GDPR applies retrospectively, and particularly given the emphasis that consent was given in the review of the directive. So enhanced consent is definitely something to look on going forward.
Thanks a lot, Lucy. And so just to bring us back to polling questions, so the results from the polling questions. Firstly, question, have you already started to audit your data processing activities against the GDPR baseline? 36% of the audience have already started that process. 42% of you are scheduled to do so in the next 6 months, and 22% have not yet started that process. In terms of the second question, have you discussed with senior management your requirements for a data protection officer? 50% of you have had that conversation. 40% of you are waiting for further Data Protection Act guidance before approaching management, and 10% have no plan to do so yet. And then the final question, do you currently use privacy impact assessments? 19% of the audience do currently use PIAs, 37% do not, and 44% use them sometimes on an informal ad hoc basis. So we're nearly now at the end of our time with you. I just wanted to let you know that a recording of the webinar and the slides will shortly be made available to you from the microsite and a follow-up email. And just also to flag with you that, as Jean-David mentioned, our next webinar will be discussing the complexities of the Privacy Shield, and that's going to be on October the 18th, and an invitation to that webinar will be following in due course. And so with that, it's just left for me to thank you for joining us today, and we hope that you can join us again at some point in the future. Goodbye.